President Biden's ghost gun ban faces another setback. Plus, plaintiff Reno May on California's handgun roster being declared unconstitutional. That and more on this episode of the Weekly Reload Podcast.
No, the devil's got no hold on me.
All right, welcome, ladies and gentlemen, to another episode of the Weekly Reload Podcast. I'm your host, Stephen Gutowski. I'm also the founder of thereload.com, where you can head over and sign up for our free weekly newsletter. If you want to get the latest on guns in America, you can also buy a membership while you're there. If you want to help support our reporting, we are completely member funded here at The Reload, and we offer a number of perks to our members, including getting this very podcast, a day early, and the opportunity to appear on the show like some of our vaunted special guests. We'd be right alongside all of the newsmakers that we have on here, and we love doing those segments. It's one of my favorite segments. So go ahead and sign up for a membership today. Buy a membership, become a member, and support our work. This week, we are talking about the handgun roster in California and the ruling against it, which is why we have Reno May, a well-known YouTuber who is also a plaintiff in the case, and California resident on the show with us. How are you doing today, Reno?
I'm doing good. I'm super excited. Big win, a big step forward for gun rights in this state and potentially nationwide. We'll see how that goes. But it feels good to be starting out on a win. This was a long time coming. A lot of people have been dealing with this law since before I was alive. And I'm happy that I get to be part of this movement forward for us.
All right. And so can you tell people just a little bit more about yourself and why you decided to get involved as a plaintiff?
Yeah. So my name is Reno May. I live in California, born here, lived here my whole life, got into guns and worked in a gun store for a little while, started making YouTube videos when some laws were changing because things were just so complicated. Things were changing. Rather than try to explain things over the phone, we figured let's just make some resources. Gun store closed in about 2018, and I decided in 2019 to start making videos again. That kind of spiraled out of control, and now it is a full-blown second job for me. Doing this has given me the opportunity to reach a lot of people and educate a lot of people about gun laws here. And, I get a lot of comments saying, hey, I was nervous to buy my first gun, and because of your education, I was able to confidently go into a gun store and get it going, because not everybody is as well versed as you and I into guns. And California is just complicated enough to where if you don't know what you're doing and you have no one else to hold your hand, it can be a little intimidating at times. Yeah. So this has been a great opportunity. When the CRPA reached out to me saying, hey, we're looking for some plaintiffs, we think you'd be a good fit, I said, yes, absolutely. I would love to be a part of this. I never thought that I would get to a point where I would be involved to this level. But I'm super happy that I have this opportunity because it's given me the ability to fight for what we all believe in at a more personal level.
Yeah, it's interesting to see someone with a significant YouTube following like yourself getting involved in a case like this. I mean, that's fairly uncommon. I mean, obviously, it's fairly uncommon for anyone to get involved in as a plaintiff in any sort of case. But yeah, certainly you sort of taken that extra step of not just advocating through your videos, but also through direct action with the California Rifle and Pistol Association there. So that's something that, sets you apart a little bit. You've seen some other YouTubers, I think, become, state directors for GOA and there have been certainly people who are more involved in activism than others. And there's nothing, I don't mean to call out anyone, but it's just interesting to see, someone like yourself take that step of getting involved legally as well. Yeah.
I was given a great opportunity, and I hope that I can make the most out of it. Having a big following kind of helps bring more awareness to it, and awareness to something that, handguns are the quintessential self-defense firearms. So it's going to be majorly beneficial to a lot of people. And I'm happy that this is something that I get to be a part of. There's a lot of creators that have been involved and, or with other things. And it was kind of inspiring to me to see people get involved outside of just news and awareness. And I was like, when I had this opportunity, I jumped on it.
Yeah. And so let's talk a little bit about the law itself, about what you're challenging here. can you just give people a background on exactly how the handgun roster works in California and the key provisions that you guys challenged?
Yeah. So the California Unsafe Handgun Act, the UHA, is a regulatory scheme that's put in place that we can only buy handguns that at certain points in time had certain features or characteristics, were drop tested, safety tested, and added to an approved for sale list. So a long time ago, in the era of Generation 3 Glocks, that meant it just had to be drop tested and it got on the list, and they are grandfathered in. So they can still be sold today. In about 2011, I believe, the state required magazine disconnects, which is a function of the firearm where if the magazine is not in the gun, it will not fire the round in the chamber. It also required loaded chamber indicators. So when there's a round in the chamber, a little flag sticks up that says loaded when up, or with text says that it is loaded, and also has some sort of visual and physical indication that it's loaded.
Oh, it has to have text
also,
on it. It has to specifically
yeah, it
say
has
it?
to have. Because when I talk about loaded chamber indicators, people say, well, the Glock Gen 3 extractor sticks out so you can feel it and know that it's loaded.
Yeah.
It doesn't say loaded when up or loaded when protruding or something like that. It has to have the text.
It's much more strict than you might, because loaded of the challenged features, loaded chamber indicators are pretty common. Magazine disconnects really don't exist anywhere outside of California.
No.
And then we'll get into the next one, but
high power.
But loaded chamber indicators are pretty common these days. At the very least, you can,
to some extent,
you can see into the chamber, or there's some sort of something sticks up or something sticks out that lets you know that the gun is loaded. But it sounds, that's interesting. So you actually have to have even more than just some kind of indicator. It has to be specifically written on the indicator that it's loaded.
Yeah, hopefully the person picking up the gun speaks English or can read English. And then in 2013, the laws changed to require what's called microstamping. And what microstamping was at the time is they wanted on 2 locations of a spent primer on a semi-auto handgun, in order to get added to the list of approved handguns, would have to put some sort of serial number or marking index that could be traced back to that specific gun. Recently, a couple of years ago, it was changed to only 1 location, which is technically more feasible because the firing pin could, in theory, work. The problem is this technology is hugely expensive, completely undesired by the market, and very impractical and borderline, I would say, personally, in my opinion, impossible to implement outside of a one-off instance. So that was in 2013. So from 2011 to 2013, a few handguns made it onto the roster, like the Shield, and that's really one of the only ones, maybe some car firearms that had the loaded chamber indicator and magazine disconnect. Since 2013, when microstamping became a thing, no handguns have been added to the roster. Now, for a frame of reference, I could not buy handguns till 2015. So every firearm that I have bought, every handgun that I have bought in the state of California has been, by definition, an unsafe handgun because they were grandfathered in. Now, our court case, Boland versus Bonta, Lance Boland being the main named plaintiff, we challenged with our MPI, motion for preliminary injunction, the loaded chamber indicator, the magazine disconnect, and the microstamping. We got that. Judge Carney issued a ruling that I thought was very fair, very specific, and we got everything we asked for, which was surprising. I was kind of tempering my expectations, didn't want to get too excited. I kind of hoped that we would get everything we asked for. But I was expecting bare minimum microstamping to get turned off, which would allow for a variety of firearms, like the Smith & Wesson M&Ps had some of that integrated into it. Some SIG firearms already had that technology in the past, but they stopped paying for the fees and drop testing and that kind of thing to keep it on the roster. But we got everything that we asked for. Yeah. But with a 14-day stay.
Right. Yeah. And we'll get into more details of the ruling in a moment, but I just want to talk a little bit more about the law itself and some of its effects, right? So one, you had no new models of pistols have been added to this list since 2013. Right? That was a big point. That was a big point of contention in the ruling from the judge. But also many have been removed in that period too, right?
Yeah. There have been challenges of this law in the past where I think it was quoted in the 1,500 range of different models, and that includes color variations.
Right.
But at that point, maybe 7-8 years ago, there were about 1,500. Now we have 832 on the roster. Only 32 of them, including color variations, have magazine disconnects and loaded chamber indicators. None of them have microstamping.
Right.
So all of these semi-auto pistols on the roster are unsafe per the state's definition. And we have no new guns. I am buying Gen 3 Glocks.
It's the only thing keeping Gen 3 Glocks going is this law.
Oh, absolutely. Yeah.
But yeah, and I believe Chuck Michelle, who's the president of the California Rifle and Pistol Association, said that there's only 200 distinct models on that list.
Yeah, that sounds about right.
Because, out of the thousands that exist.
If a gun has a different colorway, the Shield has, Smith & Wesson Shield 1.0 has about 6 or 7 different color models on it. And they're all the exact same gun, except one of them's OD green, one of them's blue, one of them's black, so there's very few semi-auto handguns available.
And they're pretty opaque about why they remove something from the list, right? I mean, I believe last year they removed the H&K USPs from the roster. Yeah. And but they didn't say why.
Yeah, we can only speculate. I have some insider sources that seem to indicate that it was something to do with the sourcing of a small part or the manufacturing methods of something like a spring. And we've seen similar issues with the Smith & Wesson SD9VE. I think was something to do with the takedown magazine disconnect mechanism. They manufactured it in a slightly different way or sourced it from a different warehouse. And that was removed from the roster as well. But the DOJ did not come out and say why. It just, in the middle of the year, the H&Ks and that one model of Smith & Wesson just disappeared from the roster. And there was no press release from either H&K or the DOJ.
Yeah, so effectively we've had this situation where no new models can be added, but plenty of models have been removed. And so it's whittling down the list slowly over time, basically, to where you're gonna be left with no handguns at some point, in theory. But yeah, so there's another caveat, I think, or complication that people should be aware of, right? This is the Unsafe Handgun Law, right? But who gets exempted from this law?
Law enforcement, including the Horse Racing Board, I believe, the Department of Motor Vehicles, and a variety of other law enforcement entities, all get excluded from this. And there has been a gray market sphere of law enforcement who buy these guns that cost $400 to $500 and then no longer wanting them and selling a used firearm for upwards of $1,500. So the police in California are allowed to both buy and carry on duty what the state labels unsafe handguns. Yep. And interestingly enough, the state's special witness from the DOJ, their expert witness on the roster, testified in court that he carries a Gen 4 or Gen 5 Glock, I believe it is, but he carries a gun that is not on the roster and is unsafe per the California definition and is not a grandfathered firearm like a Gen 3 Glock. Yeah, funny how that works, right? Yeah, if it was truly about safety, he would be carrying a gun that was safe. Yes. So, I think that pretty well explains how this law works. Let's get a little bit into the ruling here. We've got Judge Carney, who ruled, this is from his preliminary injunction. He says, Californians, quote, Californians have the constitutional right to acquire and use state-of-the-art handguns to protect themselves. They should not be forced to settle for decade-old models of handguns to ensure that they remain safe inside or outside the home. And he further went on and said, quote, these regulations are having a devastating impact on California's ability to acquire and use new state-of-the-art handguns since 2007, when the loaded chamber indicator and magazine disconnect safety requirements were introduced. Very few new handguns have been introduced for sale in California with those features since 2013, when the microstamping requirement was introduced. Not a single new semi-automatic handgun has been approved for sale
in California. So, it seems he's come down on your side, effectively believes the arguments that you guys made. Can you just talk a little bit more about what you think convinced him?
Yeah. So Judge Carney was, I believe, a Republican appointed judge, which doesn't always mean that they're going to decide a certain way. And Judge Carney had not in the past ruled on a case like this. So going into it, we were optimistic, but we didn't really have a good track record. This wasn't a Judge Benitez who has issued multiple rulings on a case like this. We hoped for the best. And in the hearing, he seemed to really want to understand where we were coming from. And he seemed to also give equal fairness to the state in hearing where they were coming from. So it seemed very crucial that we illustrated the effects of this. And Lance Boland, I think, was a perfect candidate for this. He's a firearms instructor in Southern California, and he discussed both how one of his personal firearms, a SIG 226 with a magazine disconnect, failed on the range where the magazine disconnect malfunctioned, and he could not load his gun and could not shoot his gun even with a magazine in it. He also went on to talk about how left-handed shooters have essentially no good options or very, very few options for a firearm that is fully ambidextrous or has a magazine release that can be put on the other side, which if you're a left-handed shooter, you either have to use your middle or index finger or use your support hand to press that mag release. And the slide locks, it's just, you're adding seconds potentially or milliseconds to a operation that is crucial to perform as quickly as possible, where seconds do matter a whole lot. And I think that was huge. In addition, I spoke about how I've had loaded chamber indicators break on one of my shields where it just no longer functioned. So if I was truly relying on it, which I never do, if I was truly relying on the loaded chamber indicator to tell me that that gun is loaded, I would either pull up a gun that isn't loaded or pick up a gun and think it's not loaded if I was relying on that, which I don't and no one trains to do.
Right. Yeah. So as a firearm safety instructor, you do not rely on mechanical safeties.
No. You physically check and visibly inspect that the firearm is either loaded or unloaded.
Yes.
And if you're confirming that it is loaded, you might pull the chamber open just a little bit, see brass, and say, okay, a round did strip off that, and now I know my gun's loaded. I put it in my holster and do whatever.
Right. It's actually very unsafe to rely exclusively on mechanical safeties, ironically.
Yeah.
So California brought up a couple of historical analogs that they believe justify these rules.
Yeah.
They first pointed to proofing requirements during the founding era, where there were barrels that needed to be proofed by inspectors and had to have a proofing mark stamped on them to indicate that they wouldn't basically blow up when used. And then they also pointed to gunpowder storage regulations from the founding era in some cities as well, which were designed to ensure that gunpowder was stored in such a way that it couldn't ignite and cause the city to catch on fire, basically. Now, the judge found that these weren't good analogs for the handgun roster. Can you talk about why?
Yeah. So with the proofing laws, it's very different to test every individual barrel to confirm that it's not going to blow up in an era where metallurgy is just nowhere near what it is today. Requiring certain features, which is what we are challenging, is the specific safety features being enforced on us, is not the same as ensuring that a firearm is made in a way that won't blow up. It's just not similar at all. And with the proofing laws, first, at the time it was black powder, which was an explosive, versus what we use now. Smokeless powder, I think, is considered an accelerant. And black powder is just a much more volatile substance. So it kind of makes sense that you don't store nuclear waste in your backyard. So if we ever have a law that we're trying to challenge to allow us to store nuclear waste in our backyard, maybe they can consider that law analogous. But requiring storage laws is not even closely related to safety features on a modern defensive firearm, because we are not walking around with 28 pounds of gunpowder. What we would like to do is walk around with a normal handgun in public or within the home, where for all legal purposes. So the judge didn't feel that those were analogous, and neither did our legal team. And our legal team knew that they were going to bring those laws up because those laws have been referenced in, for example, the Duncan, Miller, and Rhodey ammo background check laws. But they're just, it's the closest thing they had other than banning Black people and Native Americans from owning guns, which they like to have their cake and eat it too by saying, hey, we don't like racism, but hey, racism said you couldn't have guns at one point, so you can't have these. Which is,
did they try to cite those laws in this?
I believe
case?
So. That was in their spreadsheet, and they did the classic, we're not racist, but these racist laws that are unconstitutional, just on their face, unconstitutional laws did exist at one point.
Right. And so the judge concluded he ruled the how and why these regulations burden a law-abiding citizen's right to armed self-defense are too different to pass constitutional muster. Basically, he was saying that, a proofing requirement, which is meant to just demonstrate that the gun will work as intended and not blow up, and gunpowder storage laws, which are intended to prevent, accidental fires, really aren't,
or like spontaneous,
right?
Yeah,
aren't really comparable to, making it to requiring a magazine disconnect and and a loaded chamber indicator, let alone microstamping, which he said was, quote, simply not commercially available or even feasible to implement on a mass scale. So ultimately he said, there really aren't any historical analogs, or at least the very least the state didn't provide any that pass muster.
Yes.
And so that was why he, under the Bruen ruling, right, where you have to, for modern regulations that didn't exist at the founding, and obviously these didn't, you don't have to find a historical twin, right? You don't have to find a microstamping requirement from 1776, but you do have to find something that is similar in the how and why. And
the vibe's got to be similar.
Right. Yes, the vibe has to match for our Gen Z audience. So it's one of the interesting things we've seen in the aftermath of this ruling is some criticism actually from the right over how the judge came down to this position. Mark Smith from Four Boxes Diners, another popular YouTube channel, who's been on the show before as well. He's a sort of constitutional expert, lawyer, and he criticized this ruling not because of where it ended up. He said it's good that it ended up at this point, but he argued that you didn't have to go through the whole Bruen analysis and look at the historical analogs, because this is effectively a ban on commonly owned handguns. And so, I'm interested in your take on it. I would imagine you don't really bother you either way for how the judge came down, but.
Yeah, I think that Mark is very smart, and I think that's a super interesting look at it. The reasons that I think that we went around this was, the big thing is when they appeal it to the ninth, they're going to look at, did the judge abuse his discretion? And I think this judge just wanted to be so blatantly clear. I'm doing this because Bruen has said that this is a standard that has to be met to say that these laws are constitutional. And I think he just wanted to, this is obviously, I'm not living with the judge. I don't have an inside track in his mind, but I guess my takeaway is we wanted it to be so clear, and we argued it that way to say, hey, look, here's the standard. We're going to argue to the standard, even if the Second Amendment says shall not be infringed, even if handguns as a whole are a protected class of firearms, we're still going to use these rules so that you can't try to say that the judge abused his discretion in any way. And yes, I agree that handguns cannot be outright banned. I totally agree with everything that Mark is saying. I think it was just a matter of, it's the strategy that we went in with, and the strategy, it worked at this level. So
certainly. Yeah, I mean, I think Mark's right in terms of. I mean, I think either way you look at it, you don't necessarily need to do the full Bruen analysis because these handguns are in common use. They've banned the most popular handguns in the country. And you can't buy a Sig 365 or a Shield 2.0 or a Hellcat or any of the guns that sell, millions and millions of units elsewhere in the country. And so it's hard to argue that they're not in common use and therefore protected, especially because you're banning the kind of handguns that people mostly use for turn to first for self-defense. But it does seem like it would implicate directly Heller. But you do the Bruen analysis, and I mean, obviously one of California's arguments has been that it doesn't ban all handguns, right? You can still buy handguns.
It doesn't infringe upon your right because you could still own a gun.
This was part of their argument, right? That it doesn't ban all handguns, and therefore it's not a total handgun ban like what DC had in Heller. So that is perhaps one of the complicating factors, but it does obviously ban a lot of the most popular handguns. So it does seem like you could get there through Heller. But I mean, you basically would come to the same conclusion with Bruen anyway, because there's not a historical analog to banning commonly used handguns. So you're kind of getting the same point, maybe taking a slightly different route. But speaking of reactions to this ruling, you've had some minor criticism from the right, but on the left, on the gun control side, you really haven't heard anything at all.
Crickets.
Yeah, that's interesting, right? What do you think of that?
Yeah. So it's, usually when there's a ruling like this, like with the mag ban, the assault weapon ban, the ammo background check ban, Gavin Newsom and the Attorney General and all the state legislators, they all roll out the red carpet and do a little press release saying, this is endangering our citizens. It's, you're putting everybody at risk by doing this, or it's politically motivated judge. The judge is in the pocket of the NRA.
Yeah, he literally said that about Benitez, right? Different judge, but same idea.
Yeah. And even though the Miller case is by FPC, which is a very different mindset, and the CRPA, while I believe has some connection to the NRA being an affiliate organization, is its own separate entity that gets funding separately.
Right.
So it's this time we got was nothing from the gun control groups. Gavin Newsom, I don't believe, has commented on it, or I haven't seen him comment on it. And the Attorney General, Rob Bonta, basically gave a non-committal statement, basically saying that he's aware of it, but he did not commit to a challenge to this through an appeal.
Here's exactly what Bonta said.
Okay.
They sent us this press release after the ruling came down. He said, "The fact of the matter is California's gun safety laws save lives, and California's Unsafe Handgun Act is no exception. We will continue to lead efforts to advance and defend California's gun safety laws. As we move forward to determine next steps in this case, Californians should know that this injunction has not gone into effect, and that California's important gun safety requirements related to the Unsafe Handgun Act remain in effect." So he doesn't commit to filing an appeal, which is, I mean, obviously in the immediate aftermath, you'll sometimes get these sort of statements from AGs. So it doesn't necessarily mean that they're not going to file an appeal, but the complete lack of,
we're coming up on a week.
Yeah. The lack
Monday
of comment is very odd. You don't see anything from Everytown. You don't see anything from Giffords. You don't see anything from Brady, who've commented on basically all of these rulings elsewhere. Yeah. And you don't see anything from Newsom. So what do you think is going on there?
Yeah, I think this kind of comes back to, I just want to talk about the big picture real quick, is everybody wants to see the NFA go away, and everybody wants to say shall not be infringed and all gun laws go away, right? But the handgun ban in this instance is the small bite that we take that allows us to take a bigger bite later. And I think the gun control groups are kind of looking at this and saying, okay, if we go all out against this and say that this law is like super important and handguns need to be banned in this way, they're kind of coming out against the most societally acceptable type of firearm. And I think they don't think that they will win long term. So it kind of is compartmentalizing this to just California potentially if they don't appeal. Because if this goes to the ninth and has a positive ruling, it could have good impacts on states like Washington that are currently going through an assault weapon ban. Maybe some sort of argument being used here applies to what they're fighting over there. So I think, especially considering that the Ninth Circuit kicked down all the court cases to Benitez with the assault weapon ban and the mag ban and whatnot, I think they kind of knew, the Ninth Circuit knew they wouldn't be able to just easily overturn this and don't want to send it immediately to the Supreme Court after the Supreme Court just issued a very big ruling in Bruen.
Yeah.
So it almost looks like they might be picking their battles. I mean, like, I don't want to do the opposite of fear mongering of like building everyone up to just be crumbling back down if this gets appealed in 2 weeks. But in the past, where it's been a 0% chance the state doesn't appeal, now we kind of have a non-0% chance that the state doesn't appeal, which would basically allow us in 10 days from now for manufacturers to submit firearms to be drop tested and safety tested and then added to the roster if the state doesn't appeal. So it's kind of interesting.
Yeah, I think that's probably a good take on it. It's a non-zero chance at this point. I don't think it's guaranteed that they won't appeal because it's hard to look. It's hard to look at the history of California and think that they won't appeal because they always appeal. But
when it's 110% chance in the past of appealing, now we're looking at, maybe it's a 98% chance they appeal. That's,
it is.
Hey, maybe we're that 2%. Yeah.
Right. And it does make sense from a tactical standpoint, as you explained there. This is probably one of the more novel laws in the gun laws in the country. There are a couple other states that are flirting with microstamping at this point, in New Jersey and Massachusetts.
Yeah, but Massachusetts has a handgun roster, right?
Yeah, there's a couple handgun rosters. None of them are as strict as California's. Maryland has one. Massachusetts has one. Microstamping is being a theoretical technology that not only is not implemented by any American gun company, but not anywhere in the world, which sort of gives you some indication of the practicality of it. But so, yeah, I mean, it's entirely possible that if you're trying to think through it strategically in a post-Bruen landscape, if you're a gun control advocate, you probably don't want to waste all of your resources on the most likely laws to get struck down. And this would seem to be one of the most likely. Probably should have been struck down after Heller, frankly, for the reasons we discussed earlier. But so you might want to compartmentalize this one away and, not worry too much about, well, all right, we lost on this point, at least these 3 points. Cause as you mentioned, there are still some parts of this law that were not challenged. Actually, just real quick, why did you guys decide not to challenge the drop testing and the independent laboratory tests?
I think a big strategy of it was, I think we knew that we could win certain aspects of it. And I think a big part of it at the time might have had something to do with the California fee shifting bill that was passed. And basically what that is let's say you argue 9 things and you win 8 of them, but you lose one of them. The state would be able to go after you for attorney fees for everything to do with it. So we wanted to kind of narrow this down. And
interesting. So that had an effect on your thinking.
Possibly, at least in my mind, because I'm thinking, but the legal team decided to do it for a variety of reasons, I'm sure. But a big part of it is you got to fight the battles that you can win one step at a time. So eventually we'll get to a point where the NFA goes away, maybe not in my lifetime, who knows, let's see, we'll see how it goes 20 years down the road. But this was just a much more palatable thing to try to fight right now, and it's showing that we were able to get this win where we could. And if we get it to a point where any manufacturer could just add a gun to the roster, they will, because manufacturers were willing at the time for limited models to add loaded chamber indicators and magazine disconnects and still manufacture Gen 3 Glocks.
Sure.
So if
they
basically
want
any
access to that
handgun,
market for sure.
Yeah. Let's, there's 40 million people in this state. Let's say 30% of them own guns. I think that's about the stat. If 1% of that buys a $600 Glock, it's a big market. And think about how many manufacturers have no access to the California market outside of law enforcement.
Yep. Very true.
You know,
so
um,
that takes us to where do you see things headed at this point? Where do you think they're going to go? Do you think they're going to be, SIG P365s on sale in California in a week and a half?
I think that if this doesn't get appealed, which I'm still, fingers crossed, I'm hoping it doesn't get appealed for selfish reasons. But obviously, if it goes to the Ninth Circuit and has a bigger sweeping impact on other states, that would be awesome for a lot of people. But if it doesn't, I think other people in other states are going to have a hard time getting some of the handguns that they want, because there's going to be a run on them. We saw this with magazines when we had that, 2-week period of time where we could buy magazines. If you lived in another state, your store was out of stock for 3 weeks because we bought all of them. I think we could be in a time where I have access to affordable, non 2 to 3 times MSRP modern handguns, which is a crazy concept.
For a Californian, right? Yeah,
for a Californian,
for Virginia, that's run of the mill stuff. But yeah, for you guys, it's world changing as a gun owner. But actually, so what would you buy first if you could select from anything you wanted?
Oh man, so I think I would probably go with 2 things. Probably some sort of smaller subcompact handgun, like a 365, something like that in that realm. And then on the complete other end of the spectrum, something like a Staccato or like a really nice 2011, something that like would be good for competition shooting. It's kind of like hit both ends of the spectrum, because I got a lot of handguns right now, but I would like to have a better concealed carry gun that's smaller than a Glock 19. And I would like to have a more capable sporting handgun like a 2011. So my bank account is not excited for it, but I am.
Those are the 2 areas where you've seen a ton of development in that time frame post 2013 that you guys have just completely missed out on. It's sort of ironic because I'm going to talk about this in our news update that comes after the segment, but I'm getting doing the training to get my DC concealed carry license, and so
nice.
Now I have to think the opposite way, because I have to get a worse gun probably, because I'll have to comply with the 10-round magazine limit. And you
start thinking smaller and smaller gun.
It's like I want to get a 365X macro and have that comes standard with 15 or 7. You can get 17
something like that
magazines for it, and instead I'll have to, I don't know, maybe I'll just stick with the regular 365 or something. Something less ideal for carry. But so you might have the exact opposite. We might be going in the opposite directions here.
I'm like, ooh, I can get a small gun.
But so tell me what's next for you, or what do you presumably this might get appealed to the Ninth Circuit, and you'd have to go through this probably for another several months at least before they're going to issue a ruling, if not longer, right? That's the more pessimistic view of where things could be headed.
Yeah, I kind of always try to look at things in the pessimistic side as far as like timelines, because I just, it could be that bad, and if it's not, I'm pleasantly surprised. So if they appeal and it takes 8-9 months to get a decision on something, I'm prepared for that. I'm prepared for this to go all the way. I know the CRPA is prepared for this to go all the way to the Supreme Court if it needs to go that far. But, I'm just happy to be along for the ride. Honestly, I'll testify anytime they ask. I'll give statements anytime they ask, or anytime anyone asks, because I truly believe in this cause. And I think that's really what's cool about being a part of this. The CRPA and Michelle and Associates, the legal team, they truly believe in this. And it's, it could take some time, if things get appealed to the 9th and then they get appealed en banc to an 11-judge panel, and then get appealed to the Supreme Court. It could be several years down the road. And, when I signed up to be a plaintiff, I accepted the fact that I would not move from the state of California, bare minimum for 5 years, because I wanted to just be here for this. I knew what I was getting into, and maybe it's done in 2 weeks. Maybe in 2 weeks, it doesn't get appealed and it goes back to the district court to get some sort of, let's see, I had it written down here. Motion for summary judgment. Maybe they have us testify again. Probably won't have us testify again. but maybe it's done in 6 months and it's all just said and done. And California gets a win. Maybe it's not. So either way, I'm ready for it.
Yeah, I'm definitely of two minds about the direction this is headed. Because on the one hand, California has not shown the desire to be more tactical in its approach to these cases. If anything, they've shown a desire to push the limits as far as you possibly could, because they're passing new gun restrictions that are extremely unlikely to hold up under Bruen. But at the same time, you do have that weird bit of silence we've had thus far. You can't read too much into it, but it does seem intriguing.
Yeah, and I have to give credit where it's due. The state definitely tried to bite off more than they could chew, which led to us getting the support of PORAC, the Police Officers Research Association of California, one of the biggest police special interest groups. The Nancy Skinner drafted a bill that's going through right now that could pass, that would basically make it so cops also can only buy on-roster handguns. And PORAC in the past has been sort of on our side in a few times. They've come out against certain things, but they specifically were like, when that kind of came out, in addition to the concealed carry ban bill that's being reintroduced, PORAC reached out to the CRPA.
Police officers.
And even just thinking of the logistics of being a police officer on duty, how do you this guy is carrying a gun, and now I have to think about what's legal, what's not, because he's on the sidewalk. Okay, is that building over there a place that he can't be, and can he be on the sidewalk? It's going to add a level of distrust to people that want to lawfully carry and law enforcement even further. So they reached out to the CRPA and said, hey, we want to support you in your roster lawsuit. And they filed a brief, and some of those statements were actually included in the ruling, referencing how most law enforcement chooses to carry unsafe Gen 4 or Gen 5 Glocks, or a SIG 320.
It would be really fascinating to see how that kind of commotion would go down if they tried to prevent police from having access, especially on duty, to these sorts of guns. That's generally why they have those carve-outs, so they don't have to deal with that sort of opposition. But
generally police officers as individuals all kind of tend to disagree with these laws. But the police unions or police chiefs and some of the bigger liberal strongholds tend to support and file briefings in support of a lot of gun control. But the handgun roster has not been one of those where they've supported that law. Generally,
usually there's a divide between the sheriffs who are tend to be more rural law enforcement,
or elected officials,
and police chiefs, who tend to be more urban law enforcement. So usually you see that divide all over the place, but it's interesting not so much in this case, huh?
Yeah, now it's they're filing briefs for us or for our side of the argument. So it's good to see that, because it's a lot harder for the Democrat politicians to say, hey, we have the support of the people, and it's putting law enforcement in danger, when law enforcement, the largest law enforcement special interest group of the state, is saying, hey, this law sucks. It's hard to say they have your support.
Yeah, that was one of the complications in trying to pass the Bruen response carry bill the first time around as an emergency measure, because the Sheriff's Association opposed it for a number of reasons. And so it's still likely to pass this session, but because they're only
requiring the 50% vote if it goes this time. But, I think I haven't heard a whole lot of press release and talk about it. Usually the politicians that are trying to draft it and pass it, they just post stuff on Twitter and social media talking about it, making press releases. It seemed a little bit more quiet this time around. So maybe they've seen how it's been struck down in states like New York or various other states. So seeing those losses, maybe they're not. Maybe
we're seeing a sea change from California. They're going to shift to a minimization strategy to try and avoid defending the least defensible aspects of their gun laws and try to put their resources towards other areas. Because basically all of their gun laws are being challenged on a continuing basis. So maybe they've decided to change tactics there. We'll have to see. Perhaps we'll have you on again to talk more about some of the stuff that's going on in California, because you're right there following it all. and also involved in it from time to time, as is the case here. But tell people where they can find more of your videos and follow you.
Yeah, on YouTube, it's just if you type in youtube.com/Reno May, I'll come right up. Guy with a big forehead, that's me. On Instagram, it's Reno May _guns. I am on my third Instagram account at this point. And then on Twitter, it is just Reno May Guns, and you can find me there. A lot of stuff doesn't necessarily warrant a video, so Twitter is usually a pretty good place. Sometimes I'll just share things from your site or from other creators that are talking about stuff, press releases, just to kind of keep you up to date on like the day-to-day of like, hey, a brief was filed, or hey, here's some things that are being talked about that doesn't necessarily warrant me talking for 10 minutes. But yeah, it's fun. We're always posting something, always talking about something every day. So yeah, I'd love to see you guys there.
Great. And thanks again for coming on. We're going to head over to the news update segment now.
All right, it's time for the weekly news update. I'm contributing writer Jake Fogelman, joined, of course, by Reload founder Stephen Gutowski. How you doing this week, Steve?
I'm doing good, Jake. How are you? You got any fun plans coming up for this weekend?
Not too many fun plans, unfortunately. I got to work a bit this weekend. The fun I had was over the week. I renewed my out-of-state Utah concealed carry permit, and that was the first for me to do a permit renewal like that from an out-of-state permit.
How did it go?
It actually was a lot smoother than I expected. It was even easier than here in Colorado. I just did it mostly online. They made me watch a brief video about suicide prevention, and then I submitted an updated picture, and it should be on its way in the mail now. It's pretty easy.
Good. Nice. Yeah, I'm still waiting on my Pennsylvania non-resident. I haven't heard anything back from Delaware County yet. So I hope that it's going to happen. I mean, if they don't accept it, I'll have to, I don't know, I guess apply in York County or something a little more obviously gun friendly,
right?
Part of the state, maybe. We'll see. They should accept. There's no reason why. That was where my old one was from. Was Delaware County, and it expired. Oh, I dropped my phone. It expired during the pandemic, and then they weren't accepting renewals, and now it's like sort of unclear. They all have online systems now, which is great because they didn't used to do that. And but it's sort of unclear reading through their website whether they will accept non-resident renewal or applications. And so I put one in. They accepted my money, so I should get a permit back, right? Presumably.
You'd think so.
But it's still stuck in like, oh, yours is being assigned to someone. They have like 45 days, I think, to go through with the process. So I still have a couple more weeks before that deadline hits. So we'll see what they do. But yeah, still waiting on that non-resident. Now I'm actually this weekend going to take a concealed carry course that will qualify me for 2 other out-of-state permits. That, I mean, I have the Virginia permit, right? I think we've mentioned this before, but that is good in 35 states. It's one of the most accepted permits in the country, actually. And yet all the places I want to carry outside of Virginia, none of them accept the Virginia license. None of the neighboring states to the north, Maryland, DC, Delaware, Pennsylvania, New Jersey, New York, none of them recognize the Virginia permit for some dumb reason. And so now I have to go through and have this whole collection of permits that say, yes, I've done gun safety training and I've passed 15,000 background checks, so I can carry in your stupid state. But whatever, so I'm going through that this weekend. It's I already did. They had a basic pistol course, the hybrid online portion that you had to complete before Saturday, which is tomorrow for us while we're recording this on Friday. But that was fairly easy for me since I'm certified to teach that class. But
right.
It was nice to go through and have the refresher. The online portion of that course, the NRA did a pretty good job with it. It's fairly straightforward. It does have some of the same problems with the purely in-person class, though, which is like some of the questions on the test aren't actually discussed in the lesson plans that you teach. This has always been something that has annoyed me about whenever I teach the in-person class, is that like I teach all the lessons that they give you to teach. And on the test, there's still a bunch of questions, like 4 or 5 questions that are just not ever covered in the class for whatever reason. And so I always have to, when I'm done doing it, because I don't do it constantly like a lot of other trainers out there do. But I always have to go through and look at the test and be like, that's right, there's these like 4 questions. So here are the answers. They're like, I'll explain what they're getting at with the questions. And that's the same thing in the online course. You go through all the training, all the lessons, and they still ask you questions at the end that weren't covered. And I'm like, what are you guys doing? I mean, I guess it must be in the handbook or whatever. You're supposed to read through the whole handbook to get these couple points that they don't cover. But like, if you got a class and you're teaching lesson plans, that should cover what's in the test, right?
You'd think so.
You would think so. But no, I made it through anyway, thankfully. And there were some nice refreshers, like some of the shooting errors, they break them out in more specificity, right? It's stuff that you would commonly call like anticipating recoil, right, or flinching. There's a couple different components to that actual shooting error that the basic pistol course breaks out into, like thumbing and fingering the trigger, and they call it riding the recoil, which I've never heard anyone else use that term. But either way, like that part was actually a pretty good refresher, just give you a little more granular insight into some of the things that people could actually be doing wrong. A lot of it comes from, jerking the trigger, but right. Either way, that was good. I've got the, it's still an online portion, but it's an instructor-led portion of the class coming up on Saturday. And then on Sunday, we have the actual in-person range portion, the first 2. So Maryland, Virginia, you need 1 session in person for the training at the range. Maryland, you need 2. And DC, you need 3, at least to get, I guess this is the way that this company covers all of the hours that are required by these various states. So yeah, we'll see. I get at least the first 2, I guess, on Sunday, and then they have to do another range session after that. And then I still have to go through the whole application process and get fingerprinted. And yeah, so it'll still be a little while before I can actually get the permit. And then, of course, DC was one of the pioneers of the expansive sensitive places doctrine that we're seeing in these other blue states now, where it's not as bad actually as New York or New Jersey, but it's still pretty limiting in where you can actually carry. You can't carry on metro. So if you don't have a car, you're pretty much screwed already, which, we've talked about some of the obvious problems with these regulations in the past and who they affect. Doesn't necessarily affect me. I have a car and I live outside of the city, but if you don't have a car and you live in the city, so good your hundreds of dollars that you wasted on that permit were. Because you can't take it on the metro. You can, and the ridiculous thing about it too is that you can carry on the metro, the subway system here in the DMV, when you're in Virginia or Maryland. So just DC doesn't let you carry on the metro. It's whatever. It's absurd. But so that's what I'm doing this weekend.
I say it's amazing what a labyrinth of laws there is in just a small little geographical area that you have to try to navigate.
Oh my gosh. Yeah, and I think I've talked about it before, but they also have these roaming gun-free zones.
Right, yeah, the sensitive places move.
yeah, in DC, the sensitive place can sneak up on you without you realizing. Literally. The diplomatic protection, anyone under diplomatic protection. So anyone in a motorcade, basically, if they drive by you, I mean, I don't know what you're supposed to do. I guess I'll find out in this class. I guess they'll teach me the specifics. Presumably, I think they have to give you a warning to leave before they could try to arrest you for something like that. But yeah, in theory, you'd have to run away from them as they approach you if you're carrying. Same for like protests. Like if a protest is coming towards you, you're not allowed to carry near protests. They actually have that in Virginia now too.
Yeah.
Whether they're permitted or should have been permitted, which you're supposed to know, I guess, as a carrier, you're just supposed to have a sixth sense about, is this, right, should this group of people, should they have a permit for that demonstration? And if so, I need to run away from them too.
Yeah, if so, their permit invalidates my permit.
Yeah, so I don't even. It's sometimes you do wonder if it's even worth getting one.
Yeah,
because I also think they don't let you carry in restaurants that serve alcohol, if I'm remembering correctly. So a lot of the reasons I would, and you obviously can't carry in government buildings. It's not like you can carry in if you go to the Capitol or something. You can't carry there either. So you start to wonder, like, where am I even going to be able to carry this gun?
right.
Once I get this permit. But I tried to get it when they first passed their initial law, and I tried to get it again when that law was struck down and they put shall issue in place. But it was kind of a bureaucratic mess at the time. And so now there's this class that now that I can get Maryland's too, I was like, well, I might as well go get the 3. I don't know. We'll see.
Yeah.
We'll see how it all turns out. But that's my weekend.
Yeah. If anything, the process will be enlightening. But speaking of other developments in the gun world, talking about rulings getting struck down, you just gave us a good update in a piece this week about the latest ruling to target President Biden's ATF rule that tries to go after so-called ghost guns. If you want to tell us what happened in this latest ruling.
Yeah, so we wrote about, I think it was a couple of weeks ago, how federal judge blocked enforcement of President Biden's ghost gun rule against Defense Distributed, which is sort of the company that was kind of a pioneer in the 3D printed gun space and has done a lot in the home CNC machines for finishing firearm parts. And so they've been a big player in the unfinished gun part space. And a couple of weeks ago, they received an injunction that blocks the ATF from enforcing this rule against them. So people can buy the parts from them that the ATF is trying to claim are not legal to sell. And now, a couple of weeks later, that same judge has extended that same protection. It's actually a separate case, but same basic claims, to Polymer 80, which is the largest manufacturer of unfinished gun parts in the country. If you've seen, an 80% lower kit, an unfinished firearm receiver kit anywhere basically in the country at any gun show, it's almost certainly made by Polymer 80. The P80 will be on the box. They're all over the place. If somebody is out there building a gun from unfinished parts, they're almost certainly using Polymer 80. It's extremely popular. And so now the ATF can't enforce this rule against them either. And that includes both the ATF had initially said, well, this is really just for kits. If you sell the unfinished part alongside tools to finish said part, then that is technically a gun now, even though it's obviously not, you can't put it together and make it a functional gun. You'd have to finish the part first. But that was the core of this ruling initially. Then the ATF sent another letter and said, well, actually, also you can't sell the unfinished part itself at all. So they even expanded it beyond the initial scope. And this federal judge says, yeah, you can't do that. You cannot just make up law on your, that's essentially what he's accusing the ATF of doing.
Right. And like we said before, it was just Defense Distributed. Now it's just Polymer 80. So it's not as though the rule itself is blocked. But as you point out, because these are pretty much the biggest companies in this space right now, that certainly deals a blow to Biden's attempt to regulate this space, right?
Oh, yeah. I mean, there were also a couple of other smaller companies that were initially the ones in the case called Vanderstock that had the rule blocked, enjoined against them. And so then Defense Distributed came in and got their name added. And now Polymer 80 has come in with their own separate suit and effectively had their name added to the list of companies that the ATF can't go after for their ghost gun rule. And now that list is, it's sort of like if you tried to ban selling bikes And then a judge said, well, okay, you can't enforce this against Walmart or Target or or Trek, the largest chain of bike shops in the country. It's like, well, technically there's still a rule here. It hasn't been completely enjoined, but one, it's all of the major players are now free to sell both the parts and the kits again. And Polymer 80 has already started doing that without fear of prosecution from the ATF. And also, I would imagine if they attempted to bring any actual criminal cases against someone else, that this precedent is going to be limiting in what they could actually do on that front, even if it doesn't technically completely enjoin them. Plus, I'd expect that at some point in the near future, this judge is going to rule on a nationwide injunction. He initially rejected doing that, but it seems to me like if you read through this ruling, he talks about how Polymer 80 attempted to comply with the rule in good faith, and then the ATF sent out that letter that said basically, never mind, you also can't sell these unfinished parts either. And that would have put them out of business is the claim in the case, and the judge believed that idea. And so now we have this injunction.
Right. And as speaking of the ATF and putting out letters and their reaction, how have they reacted to this latest ruling? It seems like they're not exactly deterred by it, right?
Yeah. Honestly, it seems like they live in their own fantasy world, the way they reacted to this. As this ruling came out, I believe it was on Sunday. And then on Tuesday, the ATF released an entire advisory that was all about how they're enforcing this ghost gun rule. And you can't, the bottom line was something along the lines of like, you can't sell unfinished parts and then have another business sell, you can't, and then sell tools separately to the same person. Right. But it's like, at this point, what are you guys even, you're just fooling yourselves, right? I mean, it just makes it hard to take ATF seriously. A lot of what they're doing makes it difficult to take them seriously at this point. They're just sort of pushing through with things that they know are not going to stand up in court. I mean, that was the pistol brace ban, right? It was pretty bizarre to watch them go through with that immediately after the bump stock ban, which is justified on essentially the exact same logic, was struck down in the Fifth Circuit. Like these rules are all just sitting there waiting to get struck down, and everyone knows they're going to get struck down. And the ATF is going for it anyway, for what is hard to look at as anything other than political reasons. The president wants them to do this stuff, and so they are, regardless of how it affects their reputation, I think, among, anyone paying attention.
I was going to say, you have to wonder if it is just an attempt to save face, because that's sort of, you saw this when the first iteration of the frame and receiver rule was published, and you started slowly seeing stories come out from maybe media outlets that aren't used to covering this space, talking about how, nothing's changed in the ghost gun market. Why hasn't anything changed? And then the gun control groups got involved and started putting statements out saying that this rule did nothing. And then sure enough, ATF comes out with a letter that says, that rule we published, well, it's actually much broader than we originally said, and you actually can't sell any parts. And you have to wonder if maybe the same thing's happening here. They're receiving blow after blow to the rule, and rather than take more criticism, they're just going to show that they're still tough on this rule. And
I think it's just bizarre. It's bizarre to watch them do this stuff. Like it's hard to come up with any justification beyond just the political influence involved. Because you're right. That's exactly how it happened. They put out the frame and receiver rule, which banned kits. You couldn't sell the tools alongside the unfinished parts was the bottom line of that rule. And then they got a lot of complaints, and it didn't actually do much to affect the market because, people just started selling the parts by themselves. And then you could find or make your own tools and jigs in other ways. That wasn't really as much of a constraint as the president and gun control advocates obviously wanted it to be. So the ATF just put out a letter that said, never mind, this is, we're completely redoing how we interpret our own rule again, a couple months after we published it. So, and of course, this didn't hold up in court. That's a big part of what this ruling was about. The judge talked about how Polymer 80, he first refused to do a nationwide injunction on this rule. And then now he's piecemeal enjoining it against these companies because later on, the ATF went further and essentially made it so that these businesses can't operate at all, and did so in a way that exceeds their authority under federal law. That's the other thing about these cases is they're not really Second Amendment cases, as much as that might surprise some people. Like the core issue here is not the Second Amendment. The core issue is agency power, essentially, the executive agency power, and the Administrative Procedures Act, which governs how far an agency can go in interpreting a federal law. And essentially, the judge said, "You've gone way too far," and part of it was that they pushed this envelope even beyond what they initially intended to. And yeah, I mean, like you watch them do this stuff, and it's hard to explain any of it beyond just pure politics, right? I mean, why would you issue that pistol brace ruling, which is going to affect way more people than the bump stock ruling did? And why would you issue that right after the bump stock ban was blocked in court? Like, right. You're just going to lose in court. It's hard to see any path where they don't lose in the Fifth Circuit, at least. I guess perhaps they hope that the Supreme Court is going to side with them, but that seems wildly unlikely, especially since, I mean, these lower courts are striking down these rules even without citing Bruen, which is the major Supreme Court Second Amendment case right now, precedent, or EPA, which is the major Supreme Court precedent on limiting federal agency power. They're certainly looking at the Supreme Court to save you from what the Fifth Circuit has done. It doesn't make much sense. You'd be hard pressed to find anyone on any side of the ideological divide that really thinks that these rules are going to last. Right.
I think that's a good point. I was going to say that the current makeup on the Supreme Court is perhaps more skeptical of administrative power than we've had in a very long time. So I think it's a tough stretch to think that they're going to bail out the ATF and right. Getting a capacious ruling on a 1968 gun law that somehow covers pistol braces and frames and receivers and such.
Yeah. I mean, it'd be one thing if they had initially come down on pistol braces being SBRs, or that in 68 when they developed the definition of firearm that it was what it is, what they're trying to make it now. But the other big problem they have is that they initially for decades said that these things weren't illegal. That was also the big problem in the bump stock case. And it's hard to look at this and try to reason through why you would do any of these things outside of the political motivations. I mean, it's very odd to watch the ATF operate this way in such a just blatantly politically influenced way. Like these are not going to stand. I mean, it's just kind of embarrassing, honestly, for them to put out that advisory immediately after their rule was blocked in the vast majority of cases, right? Like, okay, you're putting out this advisory. Who does it even apply to anymore?
Right. Yeah, no kidding.
So anyway, yes, the ATF was very much undeterred. But let me give you a quote. I know I've been pretty critical of the NRA, the ATF here. So I'll let Director Dettelbach speak for himself. He said, quote, "People who engage in the business of dealing firearms are subject to the Gun Control Act. That means they need to run background checks and sell guns with serial numbers. That is what the ghost gun rule is about. Today's advisory is simple. If you're dealing firearms, including items that can be readily converted to a working firearm, ATF is going to make sure that you are following the same laws as everyone else." So that was their perspective on why they issued that advisory several days after a judge almost completely gutted the ghost gun rule.
Yeah. It's certainly an interesting choice. As you said, it's hard to see it as anything but a political, face-saving measure.
Yeah. I mean, you can understand why President Biden keeps pushing these things because
right, it's part of his agenda.
That's his agenda. That's his political agenda. I mean, that's what he's believes in. That's what he has advocated for. He doesn't necessarily care if he loses in court. And, you could certainly, the ATF serves at the pleasure of the president to a certain degree, but I don't know, they continually are doing things for, it seems, explicitly political reasons. It's hard to come up with any other potential justification for this. So anyway, that is all the time we have today to talk about this. And we are happy that you joined us. If you like this sort of reporting, if you want to help spread the news about our news, you can go ahead and like or share this podcast. You leave a review on your favorite podcasting app, or you can leave a comment on YouTube or on thereload.com, where, of course, you'll have to be a member to leave one of those comments. But if you do become a member, that was, of course, the most direct way to support our reporting, because that is how we fund the Reload, purely through member dues. And you get, of course, a number of perks. If you become a member, you will get this podcast a day early. You'll have the opportunity to appear on the show. We'd love to have another member segment. We had one not too long ago with Liz Mayer, but we'd love to have someone else on in the future. Just reply to your Sunday newsletter, which is also another member perk. You get an extra newsletter each week, and let us know you want to come on the show. But that's all we've got for you today, and we will see you again soon.